Patrick Goggin, what a pleasure and an honor to have you on Hemp Barons. Thank you so much for being with us today.
It is my pleasure, Joy. I've been looking forward to this moment for a while.
Yay, me too, brother. What a hemp hero. I mean, this plant has been through such a journey since the first law surrounding it in 1619, ordering farmers to make trial of the Indian hemp seed, all the way through being completely barred with hysterical prohibition to now reemerging in the broad light of day. And it is lawyers and the law who have in so many ways been our champions since 1970 and the Controlled Substances Act. But you, sir, you first and foremost have really been the pioneer and the hemp hero with a law degree and a license that has been carrying this ball and marching hemp down the field since 2000, really since the turn of the millennium. Really, that first lawsuit, and I'm going to just frame this up, brother, and you'll correct, or if I've gotten ahead of my skis, you will please correct anything I may misspeak on. You know, Jack Herer wrote that very first iteration of Emperor Wears New Clothes. It came up in an almost newspaper format, then printed in a real book format in 1988. And that spurred this resurgence of the hemp industries. And by the mid 90s or so, man, we started to gain a little bit of traction here in the United States, particularly thanks to stakeholders such as David Bronner and Dr. Bronner Soaps, John Rulak with Nutiva, who started to add for Dr. Bronner's hemp seed oil into Dr. Bronner's soaps. Castile soaps, and John Rulak, who started to import hulled hemp seeds and the like to sell for its nutritional profile, its omega profile and proteins. And as we started to gain some traction, we started to gain some attention from the Drug Enforcement Administration. And then right around 2000, actually, I think you could tell me, October 2001, an interesting rule was filed, and that was an interim rule, I believe. Again, you'll correct me if I'm wrong, that would seek to declare just arbitrarily that the exempt parts of the plant, such as seeds that are not capable of germination, would be considered to be controlled substances. Thereby, if they were to get away with it, the Drug Enforcement Administration would have stymied and completely stifled the tremendous progress that we had made. And that was a controlled substances if made for human consumption. May you please now elaborate what happened with that case, which we know we refer to these cases as HIA versus DEA. They're also known as Hemp 1, 2, 3, and 4, because DEA has been had to be sued 4 times, and you've been there for all of them.
So, Joy, you've done a really good job in laying the table for this, setting the table. But there's one piece of activity that occurred before that, and that was a memo that was sent from the Office of National Drug Control Policy under the Clinton administration to the DEA. And what it essentially said was that hemp is a stalking horse for marijuana. It will pave the way for marijuana, therefore, and we need to do something about that. We believe that since there is some natural amounts, negligible natural trace amounts of THC in those foods, that hemp foods that are being on the market, we want you to declare them illegal. And so at the ONDCP's behest, they issued, as you aptly indicated, an interpretive rule and then a proposed rule. Both of those were challenged. Hemp 1 challenged the interpretive rule, and Hemp 2 challenged the proposed rule. And in both of those cases, we were successful in getting a temporary restraining order. Therefore, by obtaining the TRO, we were able to show that there was a substantial likelihood of prevailing on the merits. And why did we prevail, or why was there a substantial likelihood for prevailing, is because the DEA just did not follow the proper procedures. They claimed that was an interpretive rule, but essentially it made illegal the following day items that just were not illegal. And accordingly, the court found that that was a proposed rule that required at least notice and comment. Of course, they did that at the same time, and so we had to challenge the proposed rule. And ultimately, we argued in that case that what the DEA was essentially doing was adding a substance to the Controlled Substance Act list, because THC at the time and today is separately on the list, and it clearly had indicated that it was the synthetic version of THC that was on the list. So therefore, what were they doing? They were adding natural THC to the list, and that requires a scheduling action. And they did so. Proposed rules were not enough. They didn't do a scheduling action. Both rules were invalidated. Importantly, the court coined for the first time in American jurisprudence in hemp 2, non-psychoactive hemp. It validated it, it legitimized it, and that would be really, I believe, the legal event, earthquake, cataclysmic event that paved the way for the evolution of the whole CBD space and what was going on in the various states for allowing for production, and then ultimately the 2014 and the 2018 farm bills.
Oh man, indeed. And that hemp 1 and hemp 2 took from 2001 to 2004. So thank you 10 million times over for that. And it's true. And I love basically the quote from that order, the Ninth Circuit order, which is Congress was aware of the presence of trace amounts of psychoactive agents, later identified as THC, in the resin of non-psychoactive hemp when it passed the 1937 Marijuana Tax Act, and when it adopted the Tax Act marijuana definition in the Controlled Substances Act. As a result, I'm continuing to quote the court's order here in Hemp 2. As a result, when Congress excluded from the definition of marijuana the mature stalks of such plant, fiber, oil, or cake made from the seeds, it also made an exception to the exception and included resin extracted from the accepted parts of the plant in the definition of marijuana, despite the stalks and seeds exception. Now, that was probably a little too much for our listeners, but indeed, that non-psychoactive hemp was for sure the legal event, and maybe also a little bit about naturally occurring. Can you talk to us about that?
Yeah, well, it gets complicated when you start referencing the language from 1937, because it's only referring to the resin by way of trying to reference the THC. The challenge there becomes, well, what about the rest of the cannabinoids, right? And did they intend to address prohibit the rest of the cannabinoids? And ultimately and clearly, what the courts have been concerned with are the intoxicating cannabinoid THC and its analogs. But in terms of natural THC, what the courts were saying is that, any negligible trace amounts of THC or resin that just so happen to get onto the products by virtue of the cleaning process and the agronomy and the processing and so forth, then that's negligible. That was anticipated and it's allowed. It's the source. Ultimately, it's the source rule. Does that part of the plant come from a marijuana plant, or does it come from a hemp plant? That was ultimately pegged at less than 0.3% for again, randomly, not based in science purposes. But there you have it. We now have hemp defined, at least right now in the United States, as less than 0.3%. That's hemp. Anything above it right now is cannabis or marijuana. I'll just refer to it as marijuana in this case because it's confusing when we start referring to marijuana as cannabis, even though it's all cannabis. But yeah, that's where we're at, and we can move on to the next question.
Yeah, no, it's fascinating. So, despite winning twice, as I like to say, against the DEA or the Clinton administration, as it were, despite that, and despite getting those orders, we still have, and just to explain a little bit of a tiny story here to share with the listeners. So, bear in mind, 2014 Farm Bill rolls along. Patrick has won this case for the stakeholders and the industry 10 years before got the order. Bump it up 10 years. 2014 Farm Bill passes. Different jurisdictions here in Washington State, where I live, took us another 2 years to legalize hemp for cultivation here in the state of Washington. So counterintuitive, because we already had 10 million square feet of marijuana canopy growing and still didn't have a legal hemp program, but I digress. Then what happens is state departments of ag, as these agricultural pilot programs begin to be taken on by the various states, because their state legislatures are taking advantage of this new freedom offered to it by the feds, to begin to promulgate rules for these agricultural pilot programs. And we've got these state departments of ag, excited to do their job, but like anybody else, they're kind of Googling. They don't have a bunch of experts to talk to. Those of us like you who have tried to make ourselves available to them, of course, but they're Googling. And so they're Googling things like, hey, is hemp seed legal? Is hemp grain legal for human consumption? And I would get calls from at least 2 different states, one of them being Washington, saying, Joy, I'm not quite sure. Do you know anything about this? We just Googled, is hemp grain legal? And we got this October 4th, 2001 press release was the first result, a press release that at this point, and now I'm talking 2016. So at that point, this press release was 15 years old. And it's the first result that the Washington State Department of Ag is getting is that absolutely, no, hemp grain is certainly not legal. In fact, it's a controlled Schedule I substance. And multiple people are getting that as a search result, that no, hemp grain is a Schedule I substance. And from there, I think you know what I'm getting at, brother, where we move on to hemp 3, and I'm going to let you take it from there.
Well, actually, yeah. I mean, hemp 3 comes at a similar time. Well, let me take a step back. In December, I believe, 2016, the DEA issues a new rule that had supposedly been proposed. I guess it was proposed like 6 years prior.
September 2011 is when it had been proposed. It sat there for 5 years.
So it sat there for 5 years. And then magically, December 2016, they decide to issue the rule based on notice that was provided 6 years before. I've never seen that in my experience. However, we were researching it and come to find out that we did see these press releases were still up. They hadn't changed the THC listing. So simultaneously with bringing hemp 3, we bring a motion for contempt against the DEA for violating the court order. And that wound up resulting in a settlement agreement whereby the DEA was required to issue a letter that we helped to fashion that properly provided guidance to agencies, federal agencies, as well as states on just what is the reality around hemp and to stop that misinformation. What was also happening was that Customs was being directed by DEA to test any hemp material coming in from overseas, and if it tested positive for the presence of any quantity of THC, it was to be seized. And that was a violation of the order. And we got that retracted and changed to, well, we got some somewhat vague language, but that wasn't the only basis upon which materials could be seized. So that was big. And there are a couple of before we move on to hemp 3, there are just a couple of things that I want to say about 1 and 2. Number 1, we got our attorney's fees paid for by the DEA. That does not happen. I've been advised by a lot of APA, the Administrative Procedures Act attorneys that are that's really at the heart of a lot of these challenges, and that the DEA just doesn't lose, and that our series of victories is historic, and I think that's pretty cool and something for us to hang our hats on.
Most definitely, brother, most definitely. And I just wanted to quickly interject here that rule that you're discussing, of course, was the marijuana extract rule.
Yes.
And it was, and it basically came out, of course, about 4 months after the, what did we call, I can't believe I'm so glad that it's dead and gone. It was the DEA in August of 2016, presumably, or they motioned or positioned that they had done this in conjunction with the FDA and the USDA, but basically their thoughts and their interpretation of the 2014 Farm Bill, at which point the DEA had decided they were just going to pat the US Congress legislature on its head and say, gee, we know what you think you meant when you made this historical definition for industrial hemp in the 2014 Farm Bill, but what you really meant was this definition. And as I often say, by the way, under the 2014 Farm Bill, the definition of industrial hemp, which was the first time ever, of course, that we created that definition and thereby distinguishing it from other forms of cannabis for the first time in U.S. history. And it was super simple, right? It was any part of the plant cannabis sativa L and any part of such plant, whether growing or not, that does not contain greater than 0.3% delta-9 tetrahydrocannabinol on a dry weight basis. So you could take that hemp plant and hand it to a 4-year-old and say, hey, 4-year-old, you can play with any part of this plant. What part can't you play with? And the 4-year-old would say, I can play with it all. You just told me I can play with any part. And we would say, you are completely right, 4-year-old. Here, DEA agent, you can play with any part of this plant. What part can't you play with? And the DEA agent would say, well, the flowering tops and the leaves and the resin, of course. And you'd sit there and go, wait a second. It's plain as day. The 4-year-old gets the definition, but you don't. So not only did their statement on the implementation, on their interpretation of the 2014 Farm Bill contradict and contrast legislative intent, which was surely to liberate any part of the hemp plant. But then in this December of 2016, they dig up, as you say, this dormant 5-year proposed rule to define marijuana extract, and they completely ignore the fact that there exists this historical new definition for industrial hemp. And so they basically say marijuana extract means basically any cannabinoid. We don't care if it comes from a cannabis plant that has not greater than 0.3% THC, or it has more than 0.3% THC. We don't care. If it's coming from the resin, it's a marijuana extract. And so that, of course, is what brought hemp 3. And it sounds to me like during hemp 3 is when you discovered, geez, we got it. And I loved, by the way, what it was titled, that contempt. As you probably well aware, all these years later, when you realize you've got to beat the DEA up again because they've still got that press release up, it was, what was it called? It was Motion for Order to Show Cause as to why the Drug Enforcement Administration should not be held in contempt for violating this court's prior order.
Exactly. And then ultimately, so we got that resolved. That was significant, because how often do you get the DEA, direct the DEA to issue clarifying letters to their sister agencies?
And they had to pull down that press release, right? You got them to pull down
and they pulled down the press release. But in hemp 3, it was a split decision in that case. The court found that the petitioners did not have proper standing because they themselves didn't comment on the original version of the rule, and that's very nuanced, and we felt like we had some pretty strong arguments in our favor, and we would have probably appealed. However, inside of that decision, they addressed the changing circumstances of the passage of the Farm Bill. And what they said was that Congress already decided this, and they have said and indicated that if a material is produced lawfully under the Farm Bill, then that is not marijuana. It's an exception, and therefore it is not covered by this rule. So in a sense, it was a victory, but a lot of folks see it as like, oh, well, it was denied. And I'm like, well, you just got to read the whole thing.
That page 4, I got a big old highlighted circle on that page 4 of that memorandum, brother. And and as you may remember, I was there for those oral arguments. I mean, it was fascinating to me. And you did just such an outstanding job. The legal team did just such an outstanding job with all of the briefing, with those oral arguments. And you could tell that there was a little bit of just some punting. I have a lot of faith in the Ninth Circuit. Clearly, they've been kind to the industry before, but there was some complexity there. But the reality is, exactly as you say, basically the memorandum said, hey, you know what? You're right. Under the 4 corners of the Farm Bill, this extract stuff is actually legal. And that part was so missed. And can we talk before we move on a little bit about an incredible thing that occurred? And that is the amicus brief that was filed on behalf of plaintiffs by Congress. Anything you want to talk about that? Which, by the way, we can say all day and all night, listeners, to the court. Listen, this was the congressional intent. We know this was the congressional intent, but until they hear it from Congress themselves, all they've got is our word for it. So with that, Patrick, anything you want to say about that immediately?
Yeah, they called out the DEA. They said the DEA was rewriting their legislation. The DEA is attempting to putting barriers around what commercial activity could occur under the 2014 Farm Bill, citing the fact that it was just a research bill. And they made very clear that part of that research was for the markets and on the markets. And how can you have research the markets and the effect of a commodity on the markets if you're not allowing for sale? It boggles the mind. But ultimately, what this comes back to is, what is DEA doing altogether? Like this is clearly a pattern of behavior. And so I think what the most pertinent question is why is the DEA so focused on spending so much resources on delegitimizing something that's been legitimized by Congress both in 1937 and in 1970 and again in 2014 and 2016? I mean, or 2018, it's been constant. And what it is, and what we're pretty darn sure it is all about, is budget relevancy.
I got to justify my existence. And when I'm not feeling as gracious as to say that, which may or may not be seen as gracious, I usually say the DEA is addicted to prohibition. The DEA are prohibition junkies.
They're prohibition junkies, and on the back end, God knows what they're up to. But it just is not okay. And I myself feel pretty good about being part of the effort to stand up and tell the DEA to go take a hike. And we've been successful at it. But this, I mean, I am part of the tip of the spear, and I represent thousands of people, or actually, I feel like I represent the planet on this mission.
You do. You absolutely do. You certainly represent the emerging hemp industries and the planet.
But there were important figures that were by my side and helping to lead the way. Joe Sandler, Donnie Wirtschafter, David Frankel, David Bronner, Steve Levine, Eric Steenstra. I mean, all of these people, Joe Hickey, John Rulak, as you mentioned before. I mean, these
Ruth Shemai.
Ruth. I love Ruth.
Me too.
She is the best, continuing to have her heels dug in Canada, doing the good work. I mean, like, I just want to, like, Bob Hoban, Garrett Graff, all of these people. These are all my brethren, my sisters, my colleagues, and I'm just a part of that team. I just want to, there's a lot of ego in the cannabis space in general, and I have learned to have an ego, but to have a balanced ego, and we all really need to practice recognition of others and their hard work.
You are telling me. In fact, I literally just am trained to repel, and people, it's amazing. And I appreciate the well-intended thought of wanting to uplift and say, it's because of Joy. And I just cringe. And it's because of an army of activists, not because of Joy. Are you kidding me? It's an army of lawyers, and absolutely. Amen, brother. And with that, let's bring it up to, and there are some sub issues that I want to discuss, but let's talk about the current case. And as we know, the Farm Bill, the 2018 Farm Bill, had various hemp provisions. They take up somewhere around approximately 30 pages of the Farm Bill, which I think was somewhere around 840 pages in its final version. In that 840 or so pages, the Drug Enforcement Administration, the DEA, wasn't mentioned a single time. Nary a time it wasn't mentioned once.
No, it was mentioned once, and that was that they don't have jurisdiction.
I'm sorry. Exactly. Literally, that's the punchline. Thank you, brother. The one time it was mentioned, it was like, you don't have a place here. Yet the USDA interim final rule, that first iteration of it, mentioned them 42 times. And you're sitting there going, wow, they were only mentioned that once in a negative vacuum way, but you're mentioning them 42 times. So please bring us up to what hath occurred with the most current suit, which is Hemp 4 against the DEA.
Well, I mean, and that the reason why the DEA is mentioned 42 times in that initial IFR is because the heat the DEA is bringing behind the scenes. The USDA has no reason to be bringing them up if they're not breathing down their necks. Last August of 2020, well, we were all really just mired in the pandemic and really just dealing with, the black swan event of our lifetime and perhaps the next lifetime. The DEA was back at it, issuing an interpretive rule that says, I would call it the in-process hemp rule and synthetic rule. And that is, number one, at any point during the process of extracting oil and cannabinoids from hemp material, if at any point that rises above 0.3%, then it's automatically classified as marijuana, notwithstanding the fact that almost any hemp extract is going to rise above that 0.3%. There are ways to do it that it doesn't, but that's the exception.
Extraction is germane to concentration, whether it's pesticides, heavy metals, the good stuff, or the psychoactive stuff.
So we looked at that and said, my God, we have to challenge this again. It's been kind of shocking through the years to see the lack of outrage subsequent to Hemp 1 and 2 in Hemp 3 and Hemp 4, where a lot of people said, well, they're right. or whatever. I mean, when you hear people's opinions on things, just try to understand what their interest is, because that will guide their perception on it.
Yes. That's another way of saying follow the money.
Follow the money, and that'll guide your understanding of people's opinions. But for me, my interest is, protecting industry and the plant and the folks that are working to have sustainable businesses, and pushing hemp's use and broadening and expanding and growing the markets.
And not to mention honoring congressional intent.
Absolutely. Absolutely. And so what we did was we filed a petition for review of that rule. They didn't go, like, it's a legislative rule that they didn't go through notice and comment. And really what they're doing again is placing something on the schedule without a scheduling action. So if they issue a proposed rule after, through notice and comment, it's still going to get challenged again. We did actually bring an action in, that petition for review was filed in the DC circuit. We also brought an action in the DC district court in an attempt to strategically ferret the DEA out. We got some good counter arguments from them that we'll be using in our briefing to the court right now.
And just so that our listeners know, because they sound so familiar and you didn't use the word appeals. So one was in DC District Court and one was in the DC Circuit Court of Appeals.
So one was the petition for review of the rule was challenged in the DC Circuit Court of Appeals. The DEA's assertion of jurisdiction was challenged in the DC District Court. And what DEA argued is, well, this is part and parcel of your challenge to the petition. And ultimately, the court agreed. That's being appealed as well. But the bottom line is the DEA cannot get beyond the fact that they are trying to rewrite the law. And if they are trying to rewrite the law, there's a process for it that they have not gone through and are very far from it. So while we've got a ways to go before this is fully adjudicated, we're feeling pretty solid about our position.
Just incredible stuff. And also, just to fill in a couple of holes there for the listeners, essentially the Farm Bill, the 2018 Farm Bill, said not only is hemp removed from the Controlled Substances Act, but tetrahydrocannabinols derived from hemp are also removed from the Controlled Substances Act. And then you even got the General Counsel of the USDA putting forth a legal opinion saying, yep, we agree. Hemp and tetrahydrocannabinols derived from hemp have been removed from the Controlled Substances Act. And then you've got the DEA saying, yeah, we're just putting forth this little innocent, interpretive sort of rule here so we can let you know how the implementation is going to happen but it was IFR, wasn't it? It was an IFR, it wasn't an interpretive rule. It was an interim final rule.
Yes.
Yes. And they say, so again, patting the US Congress on its head and saying, okay, so we get that what you wanted to do really was to remove tetrahydrocannabinols derived from hemp from the Controlled Substances Act. But what you really meant was tetrahydrocannabinols not greater than 0.3% delta 9. And so that's how we're going to go ahead and interpret that.
Because sorry to interrupt, but because the DEA are they're the experts. And who is Congress to be telling DEA how things ought to be done? Well, actually, Congress is who needs to be telling DEA how things ought to be done. I mean, the DEA can go about doing things on its own, but they've got to go through scheduling actions, and there's checks and balances that the legislature have placed in their way or for them to abide by. And who gets to be the arbiter of those conflicts? It's the courts. And thank God for the
Amen.
courts.
Absolutely. And essentially, what you're saying is DEA has to follow the law like all the rest of us. And this beautiful system that we do have in this country, where we have these three branches of checks and balances. And over, we literally, between 2014 and 2018, I called it the executive branch versus the legislative branch time. And then it took the judicial branch through, thank goodness, your leadership with HLG, to bring this to the court to work it out, as you say, the arbiters. So, and is there anything else, by the way, that you want to mention about hemp 4 before we start talking a little bit about California, mister?
Well, I guess the only thing, since you brought up HLG, the one thing I would mention is that this year's been a year of transition. HLG, Hoban Law Group, merged with Clark Hill. I decided, for my own reasons, to bid farewell to HLG, as did some other folks. But I'm very grateful to Bob Hoban. I'm very grateful for the opportunities that I had, and I look forward to ongoing continued collaboration. But we all, together with several attorneys from Vicente Cederberg and Rod Kite, we're all a part of this, and we continue to be a part of it, whether we're with Hoban Law Group, Vicente Cederberg, or whomever. We're still a band fighting the good fight. All right, segue, California. So a little bit of background on that front is I grew up in a political family. My father was a state assemblyman in California from 74 to 84. So while I didn't grow up knowing a lot about the legislative process, I guess I learned it through osmosis, for better or worse, or that's the way I would characterize it. But I got the bug. I got the bug somehow that that like I could actually have influence, make an impact on things. That, again, for better or for worse. And I still don't know quite how much influence and impact I've been able to have, but I think we've seen a lot of change, and that's been a good thing. Um, but after Hemp 1 and Hemp 2, Vote Hemp was working on the reintroduction of the Hemp Farming Act in California, as was being authored by then Assembly Member Mark Leno. And we went through 8 years, 3 vetoes, to finally getting to a signature. But that signature was on a piece of legislation that was, quite frankly, in large respects, gobbledygook, because it was needing to deal with the federal prohibition, leaving it to federal action for it to get going, and to deal with like a lot of the law enforcement lobby in the state and their influence on those 3 vetoes. And so it needed a lot of cleanup. It got a little bit of cleanup in Prop 64 in 2016, but we ran another piece of legislation. I think it was in 2017, that was further cleaning things up. We found a really good lobbying group. I worked closely with Will Clyden at Ojai Energetics. Eric Steenstra was a part of this. We brought in other folks, and we ultimately, after running this bill and getting it signed into law, we decided that we needed to start something to create presence in Sacramento beyond the individuals. So we formed something called the California Hemp Council, which is, it's industry funded from, state companies. Just, what our future looks like is, who exactly knows, but we had a good run here over the past several years in starting to shift our attention from production to manufacturing. And in July of 2018, the CDPH, our Department of Public Health, decided that it was going to issue an FAQ that parroted the FDA's prohibition adulterant status of CBD in foods and dietary supplements. It didn't name cosmetics, mind you. But based on that, and we clearly disagreed with their position.
Well, and they went so far as to say that really the only lawful place for the distribution of those products are in licensed marijuana dispensaries. That was the other piece to that. Am I right?
Or if you want to go get Epidiolex.
Yes, or an approved drug form. Yes, exactly.
So we said, okay, well, if the FDA is not going to regulate it, and if CDPH is taking this position, that we need to mandate it. And the way we mandate it is through legislation. So we started that process in 2000 and in the 2019 legislative session, and we were rolling, baby. We were rolling through the committees without a vote against us, and then lo and behold, at the end of the session, mind you, we went out and we formed a strong coalition, including marijuana industry, the CCIA, the California Cannabis Industries Association, Caliva, a number of cannabis interests, marijuana interests, were on board and aligned with this, because part of what we were also trying to achieve was not only the legitimization and the regulation of hemp manufacturing, we wanted to create a pathway for hemp products into marijuana retail and as an ingredient input into the marijuana manufacturing space. So what happened at the end of that session? Well, Southern California cannabis retailers and manufacturers, and some manufacturers or Humboldt Growers Alliance, like, they came out feeling threatened, opposed the bill, basically acting as though they had some sanctified place where nobody could compete with them on anything to do with cannabinoids. And that, frankly, is an unacceptable position. Hemp is an agricultural commodity. It is not prohibited by the federal government like marijuana is. It is distinct and different. But no matter how often we said that, we couldn't really get them to listen. But their first issue was, we want it tested like cannabis. We want it tested exactly like cannabis is. We have to do all this testing. You guys have to do it. And we conceded and said, okay, we will adopt. We will go for testing parity, but we will do it on our terms, not according to your protocols. Again, there's a reason why you're in the box. We're not in the box. But then that wasn't enough. Next turn to their attention to was capping THC amounts in products. And what they wanted it to be capped at was less than 1/10 of a milligram of THC. And we fought that. But and they would use this example of, well, if you allow it at 0.3% and it goes into beverage products, then you're looking at a liter of water having 125 milligrams potentially of THC or whatever, some crazy astronomical stuff. And we just couldn't get them to say, well, that's not going to happen. And even if it does, you're going to have the CBD counteracting the THC and all this different stuff. But what we ultimately, like this process is, the legislative process is about finding common ground. How can we strike compromises and accept those compromises for the good of progress? And so what we did was we posited, and ultimately it became part of the legislation, that final form hemp extract input needs to be less than 0.3% THC. And while that may not be a very elegant solution and not be liked by the industry, it was something that was a lot better than this 1/10 of a milligram THC cap, and something that we thought the industry could live with. Well, now they're going to have to. I mean, in a sense, with legislation, back in the day, California technology forced catalytic converters. I mean, legislation forces the development of technology, of activities to be better. And so therefore the legislation is requiring that companies get better at refining and limiting the THC. But last year we faced, again, steamrolling through the committees, we faced late opposition coming from the hemp farming side. And it was because the administration put at the 11th hour a smokable hemp product ban into the legislation. And while we obviously that wasn't something that we agreed with, but the way it was drafted, it was really kind of ambiguous, vague, and we were not going to die on the vine and let this thing fail because of a perceived prohibition that we didn't think existed, but at the same time that we were committed to continue to work on. At the end of the day, it didn't get passed. And in fact, it was actually inter-house squabbles that were occurring that stopped the passage. So fast forward to this year, everybody, the administration, Aguiar Curry, the author, all of the coalition was committed to getting it done. Third time's the charm. We've been through the pandemic. We've got to get this done. We've got to protect consumers. We've got to force the Department of Public Health to begin to deal with and regulate this and not keep its head stuck in the sand.
In a major way. And just so familiar with this because, of course, the California Hemp Council and the U.S. Hemp Roundtable, and I serve on that board, former executive vice president, and very much on the state lobbying committee fighting these fights, particularly this year.
So, but at the end of the day, the cannabis manufacturers were like, they got the union opposed and active, and then I think the American Cancer Association came out and opposed. So we were, and the hemp farmers were all up in arms, even though the smoking prohibition was removed. It was changed to an inhalable product. So does that include flower? I'm not so sure. It seems that it's open to interpretation, but that those products will be allowed when there's a tax adopted, and that there is a commitment next year to carry legislation that will apply a tax, and that actually is a positive, because there will be some reasonable tax on smoking products that will hopefully help to alleviate some of the tax burden on the marijuana side, which has really been challenging to dent the black market space. But also inside of that is that any of these products can be sold from California outside of the state. So a lot of the perceived concerns with the legislation are really nothing more than overblown smoke.
Yes, and I have seen that. And, normally it's true, once a law passes, generally you have to have regulations to be written. That's not a shocker when that occurs, and it takes time. And I have just seen all kinds of different reactions to it. And one thing I know for sure, and that is that we are absolutely want to 100% support farmers. Hemp, I have stamps that I made in the early 90s that I still have. I owned a hemp store in the mid 90s, and they would say, reinvigorate the family farm. I mean, this is about farmers. So everybody wants for farmers to succeed.
Absolutely. And that's why I've been doing this. Little do they know that this is going to only open up opportunities for farmers. This legislation is opening up the floodgates for.
It creates a legal pathway.
The demand will be there. They may not be getting ridiculous profits, but they're going to get sustainable profits. And just to put, a final point on it, the legislation was signed by the governor on, I think it was October 8th. It has urgency status. It goes into immediate effect. CBD hemp products are no longer an adulterant in the state of California. And companies have 90 days to get compliant. And meanwhile, CDPH has 90 days to get some emergency rules issued so that folks can comply and know how to be compliant. But the legislation itself does a good job of laying out a lot of the requirements, including the labeling, and that's really an important piece to anybody that is interested in benefiting, any companies benefiting from this. Make sure you do your labeling, and make sure if you're a manufacturer that you're looking at the regs, you're getting licensed, registered and licensed under the Sherman Act, and you are becoming an authorized industrial hemp manufacturer. But at the moment, the pathway is being created.
Absolutely. And for those who don't know, the Sherman Act is basically California's state version of the Food, Drug, and Cosmetic Act. I think that's the most simplified terms that I can explain it.
That's exactly how I would say it. But what's interesting about it is that our Department of Public Health under the Sherman Act is really an extension of the FDA. So what have we just done? We have just compelled an extension of the FDA to regulate CBD. How that ultimately kicks the FDA in its ass to get its regulations going and adopted remains to be seen.
Yep. No, it's true. And we shall see. Now, as we come to a close here, this is really a great segue. And of course, you and I, we're oilseed and fiber people. And now, because it hit us like a ton of bricks and kind of blindsided most of us 6 to 8 years ago, yes, it's true. We're also hemp extract people. But the trillion-dollar industries, the sustainable income for farmers, the sustainability and regeneration for the planet, it's in the trillion-dollar industries of this plant, and that's oilseed and fiber. So and
the herd and the insides of the
it's true. It's so interesting. When I say fiber, I mean bast and herd, but you're 100% right, brother. There is that distinction being made. So the fiber, the bast or the bark on the outside, and then of course that woody core, which I still refer to as fiber, but I am so glad you mentioned that. And again, that's where the economic and environmental sustainability is going to come. And that's where the trillions of dollars are going to come. Certainly, hemp extract is a multi-billion-dollar industry, but we're talking about trillions. And hemp extract often and CBD often takes up all the air in the room, et cetera, as it has done in this podcast in so many ways. But let's talk about, and I also want to say here that obviously there was a massive overproduction. Julie Lerner, who I adore from Pan Exchange, she wrote this great op-ed a while back for Hemp Industry Daily that said, hope is not a strategy, so stop tolling. It takes a little bit of hemp to make a whole lot of distillate. So when I see new farmers coming in, or existing farmers who, instead of wanting to do, say, variety trials as they wait for infrastructure on fiber and grain, they're believing that they're going to make so much money on hemp extract varieties. I often say, do not pass go, do not collect $200, and please do not get into hemp extract farming if you have no experience and no contract. It's constantly saying to folks, maybe this is the year of stand down, and next year too, 2022. Because as we know, in order to deliver on the dream and the promise of hemp, we need infrastructure to process the longest, strongest stalk in the world and that incredibly nutrient-dense seed within, let's say, 50 to 100 square miles of every biomass feedstock. We don't have that. So I'm trying to encourage farmers to stand down, do some variety trials on grain and fiber types so that we can see in your climate, in your soil, in your photo period, what grows. Because when infrastructure comes to a town near you, you'll know. So let's talk about how can we incentivize, particularly California, the fourth or fifth, I think it fluctuates, largest economy in the world, to grow oilseed and fiber varieties. How do we get that done?
Well, look, I mean, I think there are a number of potential avenues for that. I mean, one interesting piece is to make it very clear that hemp can avail the production of hemp avails carbon credits. If we can get carbon credits applied to it, then that's an incentive. If we can create tax incentives for companies to be doing R&D, to be looking at energy production, to be looking at uh, uh, literal infrastructure use of hemp in road making, other infrastructure capabilities. I know that there's work already being done on the nano the side that's working with to replace graphene and graphite. But it's so often in California, we're hearing about like Tesla just left, and companies leaving because the cost of doing business here is so high. Well, California simultaneously has this the Climate Act, and it's always led environmentally. So, what if we were to create these tax incentives for major businesses to get the R&D done and to start investing that into that capital, creating the infrastructure for truly addressing the issues. Look, the federal government is doing very little to effectively combat climate change without, I mean, it's working to overcome the past 4 years of serious ostrich acting head in the sand. But the US, in the past has led the way. California leading the US in pushing the planet. But California, like I said, mentioned earlier, we forced the catalytic converter. Why can't we force? And it doesn't need to just be hemp. It can be all of the plant-based resources going into the global climate solutions. What are we doing? And this may be getting outside of hemp in part. What are we doing to sequester the carbon? Does hemp play a role in that? Yeah, it does. It's pulling it out as it's growing. So
and locking it in. And let's not get started on hempcrete and carbon sequestration because of the lime. Oh my God.
But bottom line, I think there's plenty of opportunity for tax incentives, tax breaks, technology forcing, work to be done in Sacramento, and we're gonna, like I often say, is the sleeves are rolled up, they're gonna stay.
Amen. Oh my! And I dare you to try to pull them down. I dare you to try to pull them.
I mean, they do. But you know what? If there's one thing, Joy, I've learned about this space, it's called resiliency.
In a major way. And I thank the plant for it because, I saw it once, a quote in print. And so I'm never going to actually do this quote again when I get, because it's kind of a cute thing that I used to say to reporters. And I used to say, man, I've tried to dump the hemp movement. It's impossible. Like I just wake up the next day, I want to slave for this plant again. But that is the reality of it. It got up in my DNA many decades ago. And it bosses me around every day. And I could not be more grateful for the joyful, fulfilling, rewarding work every day that it is working to deliver on the promise of this versatile, valuable plant. And Patrick Goggin, I am so grateful that you got bit by the hemp bug too.
Yeah, well, my brother. Okay, so I was a history major at UC Santa Barbara, and I took this amazing class called The History of Wilderness and Civilization, and it changed my life. It got me back to who I originally was, and that was somebody who really cared about the water I drink, the water I swim in, the air I breathe, and the plants and critters around me. And I was ripe for when my brother delivered to me as a birthday present The Emperor Wears No Clothes, probably in one of its early print editions. And And that led to me, after my first year of law school, I was up in Portland and Lewis and Clark, getting really moldy as hell. I came back to California. My mood lifted, and I went to this concert. It was called Laguna Seca Days, and that was the moment at which I saw the plants. I saw the plants in the field. This was 1993. And I was preaching from the soapbox at Laguna Seca Days. And I was like, can't you see those plants? They're coming. Little did I know it was going to take 30 something years. But again, coming back to these lessons in life and experience of facing defeat and dealing with loss and dealing with defeat. We have to retreat. We have to feel it. We have to process it. We have to grieve. But God damn it, we got to get back on the horse. And we will not stop until we are relaxing and we are drinking our plant-based beverage from a biocompostable plant-based cup, and that will be able to thoughtfully discard and know that it's going to go away. We are going to remove plastics from the petrol-based plastics from our existence. We have to. If we don't, we're going to choke on our plastic as the animals are doing. We got to get, that's why I get so tired of the bickering over people's self-interest and profits while the planet and the animals and the plants are dying. We're the stewards. We're responsible.
110%. And after all of the momentum that we made, I will not be dying on the hill of synthetically converted Delta 8 so someone can get intoxicated when we've got to do all of this work. And again, it's a constant. As the free market and as science catches up with the law, we've got to continually monitor and modify and adjust here. But 110%, those selfish special interests really need to, and it's shocking to me where it comes from, because we used to be able to smell them coming a mile away, and now they're sort of like foxes in the hen house. But that's what we do. That's what we do. We continue to be the steward and to be the voice of the plant. I often speak in the first person, and someone will say, what did you say? Oh, I'm sorry, I wasn't talking about me. I was talking about hemp. I know, but you said I, and you said we. Well, I was speaking on behalf of the plant. Sorry.
They call that pantheism.
Thank you. Okay. Apparently I practice pantheism occasionally. My gosh. Brother, I am so grateful for everything that you are, everything that you do. I am so grateful for your conviction, your sense of conviction, your sense of duty and obligation. You are a personal hero of mine and a hero to the planet and a hero to the farmers and the hemp industry, Patrick. Thank you for being with us today.
Thank you, Joy. Those words are helping me to melt but feel really good. And I'm honored to be on this path.
Oh, brother, thank you. Until next time, I'm wishing you everything wonderful. Power to the people.
Power to the people.